Welcome to the Sea Change webinar entitled Changes to the HIPAA Privacy Rule, Progress and Next Steps for Sea Change. I am Payal Shah, Sea Change's staff lead on HIPAA and today's webinar moderator. The goal of today's webinar are to provide Sea Change partners and members with an update on changes to the HIPAA privacy rule and discuss next steps for Sea Change. This webinar will be recorded and available through the Sea Change website and social media pages tomorrow. The Q&A session will occur at the end of this webinar. Please submit your questions via the questions function throughout the webinar or at the end. We will attempt to get as many questions answered as time permits. However, questions that are not answered should be emailed to me. Participants joining via phone will not have the ability to pose questions, so we highly encourage you to join the webinar online. Let me start with a special thank you to Hogan Lovells for their pro bono support to Sea Change, and in particular the HIPAA initiative over the last several years. I'd like to take a few minutes now to remind you of Sea Change's work in research to date. Sea Change efforts in research started with the objective to promote clinical trials. The committee recognized that one unique item that we needed to pursue together was to create a clinical trials guidance document for policymakers. We completed this document and it was widely disseminated. The committee then quickly came to the consensus that the next major problem Sea Change was uniquely placed to solve together was based on an IOM report that stated that that HIPAA did not successfully protect people from privacy and substantially hindered research. Through a legal analysis completed with our partners, we agreed to legislative and regulatory changes that needed to occur. In collaboration with Indiana University and many Sea Change partners, we submitted several comments to HHS and drafted model legislation, both of which Stan will tell you more about in a few minutes. In January 2013, HHS issued a final rule that addressed many but not all of our HHS comments and concerns with HIPAA and our overall objectives. Our speakers today will talk to you in more depth about recent progress and next steps. Our first speaker, Stan Crossley, is Director of the Indiana University Center for Law, Ethics, and Applied Research in Health Information, as well as Principal in Crossley Law Offices. He is a former Chief Privacy Officer for Eli Lilly Company, where he initiated Lilly's Global Privacy Program in 1998. Stan has been working with Sea Change on this initiative for several years and recently agreed to serve as co-chair of the Sea Change Advisory Committee entitled Accelerating Life-Saving Research While Better Protecting Patient Privacy. Our next speaker, Melissa Bianchi, is partner at Hogan Lovells. Melissa's practice focuses on healthcare regulatory and privacy issues, and her expertise includes the HIPAA and high-tech regulations. Her advice has been invaluable to Sea Change for several years. She will present on the 2013 HHS update to the HIPAA regulations. Finally, Dr. Roy Jensen is Director of the University of Kansas Cancer Center and Distinguished Professor at the University of Kansas Medical Center. He has over 150 publications, and his laboratory was instrumental in demonstrating the role of the BRCA1 gene in growth control of normal and malignant cells and how loss of functional BRCA1 contributes to the development of breast cancer. Dr. Jensen is also co-chair of the Sea Change Initiative, and today we'll review our strategy next steps. Please give your attention now to our first speaker, Stan Crossley.
Thanks so much, Payal. I really appreciate it, and good to be speaking with all of you folks. As Payal mentioned, we've been working at this for a little while. The problem was really originally articulated with the IOM panel I was a part of, beyond the HIPAA privacy rule, enhancing privacy and improving health through research, and a publication that panel did in 2009. And Sea Change has done an incredible job of taking that message and socializing it and really kind of moving it through very important channels with all of your contacts. And because of that, we've made some great progress. In general, as most of you probably know, the barriers that we were concerned with were the barriers that were created with the regulation, HIPAA,
to study-specific, they removed that study-specific limitation and the limitation on future unspecified research. And they also really changed the rules around compound authorizations. And those were critical wins. Not all the way there, but very important changes in the privacy rule that we hope are going to make a difference in research. So let's go to the next slide, and we'll talk first about the study-specific limitation. So as I said, HHS's longstanding position under the privacy rule has been that research authorizations may not authorize future unspecified research. And when you are engaging in a clinical trial, you need to get both the patient's informed consent and you need to get a HIPAA authorization. Sometimes those documents are combined and sometimes they're separate, but all of the HIPAA elements have to be present. And while under the common rule and in the informed consent rules, you can get informed consent for future research, HIPAA did not allow that to the extent that we couldn't name or specify the research. And that's because the privacy rule has a list of requirements that for a patient authorization. And one of those requirements is that an authorization describe the purpose of the requested use and disclosure of the protected health information. And it's, what HHS has struggled with is what that purpose was supposed to be and had interpreted the purpose requirement as meaning that you had to specifically describe the study in order to meet that purpose requirement, and you could not obtain authorization for uses or disclosures of protected health information for future unspecified research. And really what HHS's concern has been is that patients wouldn't have the information necessary to provide informed consent about future research. The problem is that has made it hard to do that future research. It's not consistent with the common rule, and many researchers have really felt that has hindered the ability to proceed with those follow-on studies. Let's go to the next slide. So a huge win in this rule for sea change and for others who have been really advocating for a change to the research provisions in the privacy rules. So the high-tech final rule changes that position that you can't authorize future research. And as of March 26, 2013, which is the effective date of the final rule, you can have a HIPAA authorization that permits future research. Now there are some requirements on that. The authorization has to adequately describe the future research such that it would be reasonable for the patient to expect that his or her protected health information could be used or disclosed for that purpose. And the authorization still has to include the core HIPAA elements. And so, I think the challenge now is going to be to figure out how to write these authorizations in a way that meets those rules. And, what we know is that you have to put patients adequately on notice of what the future research might be. And they have suggested in the preamble discussion in the final rule that might include specific statements on potentially sensitive research. There are a wide range of statements that you might be able to use. And I think one of the things we're going to be doing now, and have already started doing, is trying to figure out how to craft those statements in a way that meets the requirements of the privacy rule and this modified interpretation, while still permitting the research the future research studies that we want to engage in. And I'm going to talk more about these kinds of examples when we talk about compound authorizations and the other changes that HHS has made to the authorization requirements. But it could be that you could have an authorization that contemplates the current clinical trial and studies, and you craft some phrase that studies related to the same disease state, to if it's a cancer trial, maybe to other types of cancer. But it might not even need to be that specific, and I think HHS anticipates coming out with additional guidance, and I think what we hope is we can get those phrases to be broad enough to permit research, understanding the concern that people should be able to provide informed consent, and that some folks may not want. And I think they were really trying to address the concern that some folks may not want their information used in certain kinds of studies that they would not be comfortable with for based on their own political or religious beliefs, that they might have agreed to this trial and similar kinds of trials, but there might be some types of studies that that people would have chosen not to participate in. And so they were trying to balance that need with, but we're generally very responsive to the research community in allowing the descriptions of future research. So that's going to be critical, I think, moving forward. So those authorizations can start now, and interestingly, they allow for certain studies to be grandfathered. And so where you have an informed consent and a HIPAA authorization wrapped into the same document, and the informed consent contemplated future research, you could use that to authorize as authorization for the future research. So if you had them wrapped together in a way that a patient would be reasonably on notice, that is something that you could do even with existing authorization. So that's an important.
Melissa, one question for you. I think in that circumstance too, could you clarify whether that would require just one signature for one authorization with the future?
For existing authorizations that they would grandfather?
No, I'm sorry, for just moving forward. Yeah.
It could require one signature. It could require two. I mean, we'll talk about the compound authorization, and you're going to have to. These rules are going to work together, and I think we'll have to. You have to figure out in the context of an authorization how to do that. Probably it's going to require two, but it's going to be a combination of describing that future research and dealing with the compound authorization requirements, which are getting authorization for two things at once, and how those are going to work together to figure out whether you're going to need one or two. So I don't know that there's going to be an always answer for that.
Thanks very much. That helps.
Yeah. Let's go to the next slide and talk about compound authorizations. Again, this is something that C-Change has been working on. Another restriction in the privacy rule historically. And this one's a little complicated, but let me walk through it. The privacy rule prohibits covered entities, hospitals, providers, health plans, from conditioning an authorization, from saying that you have to sign the authorization in order to get care, for example, or you have to sign the authorization in order to get payment for that care. And the reason for that is that it's intended to ensure that patients are providing their authorization voluntarily, and you shouldn't be able to require a patient to give their authorization when they walk into the hospital and need treatment, right? That they should be able to get that treatment, right? And so that's the concept behind saying that you can't condition authorizations. You can't say you have to sign this in order to get the care you need. But there are some exceptions, and importantly, there is an exception for research-related treatment for clinical trials. So, which makes sense, right? Because a patient is able to get the care. And if that care is available outside the clinical trial, could choose to go that route. But even if the care is not available outside the clinical trial, basically it's sort of that trade-off of you can get to enroll in this trial because it's a particular treatment you need, and are willing to do something that's still being researched, and you have to agree to participate in the research study in order to get that care. And so there's an exception to that limitation on conditioning, making somebody sign something to get care when it's for research-related treatment through a clinical trial. The privacy rule also generally just doesn't, prohibits compound authorization. Where an authorization is for the use and disclosure of protected health information, and it's combined with any other legal permission. So again, there is an exception to that. So you can't have a HIPAA authorization that's also getting somebody's permission to do something totally different. And there's an exception again to that general prohibition on compound authorizations that allows the combining of an authorization that's for a research study with any other written permission that is for that same complexity. So you can have a HIPAA authorization and an informed consent in the same document because there's an exception that says, yes, it's compound, you're asking two things, but that's okay in research because it makes sense in research. So you can get an authorization and informed consent together to participate in research. But it's a little bit, but that often hasn't worked that well to get a compound authorization in research because you also can't get a compound authorization that authorizes conditioned and unconditioned activities. So you can't authorize a research activity for which the treatment is conditioned on signing the authorization, right, enrollment in a clinical trial, with an authorization for research activities for which your treatment is not conditioned on signing the authorization, and that would be unconditioned. And this is true for most cases of future research, right, where you're not still working with a patient, but you need that patient's data. Where you have typically the scenario that this has often shut down or always shut down is a clinical trial that's associated with corollary research activities. Biospecimen banking, if you're going to form a tissue bank as a corollary research activity, I mean, the patient doesn't need that tissue bank, right? Is not getting treatment from that tissue bank. So that's not a conditioned authorization. That's just an unconditioned authorization. The patient can sign it or not. He or she doesn't get anything other than sort of general contribution to research, but there's no treatment contingent on allowing your specimens to be given to a tissue bank. So that's unconditioned. So you can't combine those two. And what that means is if you have a clinical trial and you're trying to put together a biospecimen bank from the tissues collected during that trial, you have to get separate authorizations. And, for the participation in the clinical trial, which is the conditioned authorization, and participation in that other corollary activity, which is the unconditioned authorization. And this has been, this has been hard to get separate authorizations for both of those activities. Has been a challenge for researchers because, first of all, it's, again, not consistent with the common rule requirements regarding informed consent. And it's multiple authorizations can be potentially confusing. They can be hard to get. And it's just been a burden, really, for researchers. And this, you can see how this relates to that sort of future research. If you were doing the conditioned, the clinical trial in which somebody is actually, engaged in getting treatment, that's a conditioned activity. But then you are looking at the data later and you want to do a research study. You don't need the patient anymore, but you need the patient's data. That's not a condition. That's not conditioned activity. And so the combination of future research and unconditioned activities, it's been hard to get the authorizations written in the way that would allow, that would allow it to get to use a single form, really, and to get patients to authorize multiple things. So let's go to the next slide. And really, again, and this is something that C-Change has been working on. They changed it, which is, a lot of the research community, I think there was a view that the research community wasn't that engaged the first round in 2000 and 2002 when the privacy rule was first being written, and perhaps because it didn't occur to us that this was all going to apply in a way that was really going to be detrimental to research. But the research community has been heard loud and clear, and so we have made some progress. We have in this final rule, in the high-tech final rule, which again, these requirements are effective as of March, so they are in effect now. You can get compound authorizations for research purposes, and so you can get a single form. And what that means is that you can get an authorization that combines that conditioned clinical trial and the unconditioned, the tissue bank research. So you're doing clinical trials and optional sub-studies. You can combine the conditioned and unconditioned activities. And this is an exception for research purposes. And you have this, the authorization has to do a couple things. Again, it has to meet all of the HIPAA requirements. The whole list of things has to be in an authorization with respect to HIPAA. But it also has to clearly differentiate between the conditioned and unconditioned research components. And you have to provide a clear opportunity for an individual to opt out to opt into the unconditioned component. And that's probably where we're going to see two signatures. You're going to have one form, you're going to initial, you'll sign once, you'll initial the second place or something like that. But you really have to have the option to choose that unconditioned component. This doesn't apply to research that involves psychotherapy notes. Those have to be basically just kept separate. So let's go to the next slide. So what does this mean? I mean, both of, oh, I think previous slide. You know, I mean, I think in sum, what these changes mean for research is that there really has been a significant change in the interpretations with respect to patient authorizations and how those forms can be gotten in a way that hopefully will reduce the administrative burden on researchers and make it easier to do those follow-on studies that has been in the past. Because, you know, that with respect to the compound authorizations, the biggest burden might have been needing to get different forms. But with respect to the future research and the unspecified future research, the ability to get permission for future studies is significant, I think. And so that's, you know, going to be a critical change for researchers and study sponsors. We do expect additional HHS guidance on research issues, which we think will just, you know, probably clarify things like what kind of phrases you can use and, you know, any additional, you know, I suppose limitations on the way you can do that. But I expect that the research community will continue to work with HHS on that piece. And obviously, this is something that C-Change has advocated for some time. I want to talk just, if we can go to the next slide, just in terms of what the covered entities are doing now, the hospitals, health plans are doing now, revising those research authorizations to permit future research, right? All of these forms are being revised now, considering compound authorizations for protocols that involve multiple research studies, investigational treatment and tissue banking, for example. Amending policies and procedures for implementing requests to revoke an authorization. What if somebody wants to revoke, they want to take back their authorization, they don't want to participate anymore? We know that you can use their information to the extent that you had relied on it already, when you've already received it, but there can't be future disclosures once somebody has revoked that authorization. But what if they only want to take back their authorization for that unconditioned piece, for that future research study, and not for the current clinical trial? You know, how are you going to manage that and not lose the opportunity to continue to have those patients participate in the current clinical trial? Obviously going to raise concerns about if a lot of patients go out and do that, about the usefulness of the data. But my guess is that won't happen that often. And what we hear from patients, and the C-Change folks can speak to this, is that they want to participate in research. They want their experiences to be helpful for others and to contribute to the general body of research. I don't think you're going to have that many patients revoking, but you're going to have some procedures in place for doing that. And you're going to have to look at your existing studies that may have, you know, gotten permission for future research in the informed consent and may have been combined with a HIPAA authorization. Figure out what that means for those trials. Can you use that data that you're collecting now for you know, for future research? So I think that's going to be something that that covered entities are going to be looking at very carefully. I want to talk just about two other things in the next slide that have also happened in this final rule, just to kind of give you a little bit of additional information. One, that, you know, I get a lot of questions about de-identification. There are not any changes in this final rule to the HIPAA de-identification standard. So we're still operating under the same standard that we've always had under HIPAA, where you have to strip the certain 18 identifiers. There was a guidance in September of 2012, a guidance document from HHS that provides a lot more information about de-identification. That guidance document tells us more about how to use statisticians for certification that data is de-identified. I think that's going to be increasingly important. I think people have been reluctant to get a statistician to de-identify because it wasn't really clear what the standards were, and people were concerned about what the risk involved was. But I think they've given some helpful guidance in terms of what a statistician can do, who a statistician can be, and I think that that will be very important. And I've already seen, even in the cancer space, but in other spaces, efforts to really use this guidance, to use a statistician to de-identify data in a way that isn't that safe harbor of removing the 18 identifiers, but keeping a couple things that you need and getting rid of some other things maybe in a way that a statistician gets comfortable that it's de-identified, so that it really gives researchers the ability to have access to much more meaningful data than they were getting under the standard de-identification. So no new news on that under the final rule, but I already, since the September guidance, am seeing a lot of big steps on sort of big databases in terms of creating big databases for research. So I think that's very, very optimistic. And finally, just want to talk a little bit about the next slide on the sale of protected health information, and just let you know that there is another set of rules here that could affect research, and that is just that there are rules in this final high-tech rule, in the privacy rule now, there is a prohibition on the sale of protected health information. And what that means is disclosure of protected health information by a covered entity or a business associate where they directly or indirectly receive remuneration. They get paid or receive something in kind in exchange for that data. It says identifiable data. But again, so this is new, and I think people are still getting comfortable with where, with how, what is this? How do you sell data in a way that's going to trigger this? But know that there also are here exceptions for research purposes. That disclosures made of data made for research purposes are accepted from the remuneration, the payment, or in kind. Prohibition to the extent that that remuneration is a reasonable cost-based fee that covers the cost to prepare and transmit the data for the purpose, for such purpose. So as long as there's a reasonable cost-based fee for preparation and transmission of the data, you're not going to implicate the sale of protected health information. Prohibition. There's also exceptions for public health activities. You don't have to limit the cost to a reasonable fee because they didn't know what public health agencies would require and what would be involved, and they didn't want to restrict that. And also know that you are not selling PHI impermissibly if you are operating under a grant and you have to report data as part of your grant obligations. And that's another just important piece from a research perspective. Know that if you are, you have a grant, you have from, say, the federal government, and that grant requires the covered entity to report the protected health information for purposes of program oversight, of grant oversight, but that is not the sale of protected health information. I think one of the concerns heard right out of the gate on the sale of protected health information was, wait a minute, what about all this quality improvement, all of these grants that we have to do this research around how to improve health outcomes and all of those kinds of things, and we have to report data in order to show that and we're getting paid, right? We're getting paid to carry out the grant. So are we selling data because we're getting paid, and part of what we have to do is disclose data? So no, and that's just another research-related issue that you may hear people talk about in the context of this final rule. So Melissa, overall, huge improvement. Yes.
Melissa, this is Stan, and just one observation on the research that allows a reasonable cost-based fee to cover the cost to prepare and transmit data. What a lot of entities are doing is, in other parts of HIPAA that have also changed, is they're unbundling agreements for this type of thing, and it's still completely permissible to pay a reasonable market fee for data analysis and analytics for records-based research or epidemiological studies for someone to do that assessment across that data. And then if they are transmitting as part of it, then a separate allocation that goes to the actual transmission and the movement of the data. So an unbundling of service agreements or contract research agreements is also being done.
Yeah, I'm seeing that happen a lot in some of the other HIPAA provisions where they've imposed limited fees.
Right.
You just have to look at how this fee is going to restrict what you're doing, if at all, if it affects what you're doing at all, and if so, we'll look at how to unbundle it and really make sure that you're meeting this requirement. I think that's exactly right. So that's all that I have. So I think I will turn it over to the next folks.
Well, welcome to our webinar this morning. I'm Roy Jensen, and along with Stan, I co-chair the HIPAA subcommittee for Sea Change. I'm new to this organization, and my job this morning is to inform you of what our plans at Sea Change are for this initiative moving forward. And just to summarize before I go into more detail is, first I think in talking with other folks in the biomedical community, many of them are aware that there have been significant changes, but they're still not certain how this applies to their specific situation. So I think Sea Change recognizes that a big job that we have moving forward is to educate people about the final rule. Another thing is that it certainly behooves us to make sure that the changes that have been really fought for are optimally leveraged. And so I think we have some specific tasks to make sure that happens. And finally, while we, I think it's broadly acknowledged that we probably got 85 to 90% of what we wanted changed with HIPAA changed, there are still some aspects that are going to require monitoring and, potentially in a couple of years revisiting this with Congress to make sure that it's we really promote research. So, so obviously, in terms of education, this webinar is kind of the start of that initiative, and it's absolutely critical that we get this information out there. I think another thing is that it's essential that as we move forward as a biomedical research community, we don't sort of fight these battles in a one-off situation. And what I mean by that is I think it would behoove us to promote and adopt common language and standards for our consent forms to make sure that we are able to maximally utilize the elements of the new final rule here. That's both obviously for cancer research and other types of research. And in particular, I think we have to pay attention to how these rules apply to data repositories, and that's going to be something which is going to be increasingly important, I think. So next slide, please. So I think a big part of what we're going to try to do as we move forward is to monitor the implementation of how these rules are affecting research moving forward. We want to ensure that they have the positive impact that I think all of us certainly hope for, and want to understand if there are any issues out there in the biomedical research community as we go forward. In fact, I want Stan to come back here for just a second and tell us about, it's sort of like the Chinese proverb, may get what you ask for. Lots of IRBs did not have adequate direction in the old set of rules and sort of made things up as they go. Well, now they have a lot more direction, and I think one of the things that Stan's going to tell you about is we need to ensure that that's a good thing and not a bad thing. So, Stan?
Yeah, absolutely, Ray. Thanks a lot. And Melissa alluded to this in her comments too, very clearly. There's still some unknown, and the combination of future research and compound authorization, could result in a very good place, and it could result in a lot broader authorizations with a lot better participation in future research and in biobanking. All the things that are really essential for longitudinal quality research to continue. But there's also the possibility that IRBs can look at this and say, well, we now know what future research is. It's anything that's not in the protocol. We now know that there's this thing called compound authorization that we've got a pretty clear handle on. If it's necessary for this trial, then that's a conditioned, and so we're good. So if an authorization is for to use the data and the samples for the information set forth in the protocol, we're good with one signature. If it's anything else, it sounds like it's a combination of either future research, which has to be clear, or it's probably unconditioned research, and so we probably at least need a checkbox. And so, previously, when there really wasn't a lot of definition, the benefit that you had was there are a lot of entities that were saying that an authorization that is for the protocol, as well as for research that is about the drug in the protocol or about the disease in the protocol, that's specific enough that we think a single authorization is good. Even though there's also argument that was future research. It was very routinely used and widely used, and IRBs widely accepted, that concept of the disease, the drug, and the trial itself were sufficiently detailed to enable an authorization. Now, there's the possibility that IRBs will come back and look at that, feel like they are empowered to look at these things with more detail, and they'll say, well, no, we want that primary authorization to just be about the protocol alone. And then anything else has to be either included as a checkbox or a separate signature. Sure, it's on the same form, but it's still a separate opt-in activity. And so, there is the possibility, as Melissa alluded to, that this could either be misinterpreted or interpreted in a way that may not give us as much of the win that we really need. And so, the monitoring activity, I think, is important to really catch it as early as we possibly can, identify if there's a trend that's occurring that is unfortunate, and then try and get back with HHS as soon as possible to see if there is additional guidance that can be delivered, or if we want to take that approach. So that's what I think we really need to pay attention to on the monitoring aspect.
Okay, thanks, Stan. So how we intend to operationalize this basically is we're probably going to have something akin to the Stan and Roy Roadshow coming to the next major scientific meeting near you, where we reach out to the organizations that are listed on the slide there, and in any other organizations that you feel might be appropriate, to really gauge the scientific community on how the implementation for the new rules are going, how their interaction with their local IRBs are proceeding. And I think we need to get an understanding of the impact that these rule changes are having. So next slide, please. So once that's done, probably a year and a half, potentially as much as 2 years from now, we'll, and when we have a full understanding of what the implications are, we may or may not decide that we need to go back to Congress. Anybody who's dealt with Congress will understand that once they've done something for you, they're pretty uninterested in your in treaties for the next 2 years until they have an understanding of what impact the new rules have. So certainly now is not the time to try and do anything. Now is the time to understand what has been done, what the implications are of that, and what effect it's having on the community. So with that, I think we'll turn things back over to Payal, and we'll get your questions and hope to answer them. Thank you very much for participating today.
I'd like to thank all of the speakers for these informative presentations, and ask the participants to go ahead and use the questions functions to ask your questions, and I can start off with some of the ones that have already come up. And this is a question to any of the speakers, and it is, how do the new changes apply to pediatric study participants? It's a two-part question. Specifically, if a third-party parent authorizes for their child's participation in a conditioned study, is the parent also able to authorize for the unconditioned associated study at the same time using a compound authorization, even if the timeline of the future study might extend past the time when the child is no longer a minor? So I don't know if I maybe start with Melissa on that. Do you have any thoughts?
Sorry, no. Can you give me the highlights again? Sorry, that was long.
It was a long question, but I think the answer is yes. I think they can authorize a study that's for conditioned and unconditioned that even extends beyond the point of when the child is no longer a minor. I think the analysis that I've certainly taken on is that the initial trial time dictates the validity of the consent. You can't monitor who in your studies reach certain age or have changes in their status that would determine whether you could continue to use their data. So another way to look at that is if someone becomes mentally incompetent, you don't have an obligation to monitor your trial participation to go back and check that you can continue to use data that someone who has now become mentally incompetent. So now if there is an additional study, you want to go back and get a further consent, and the original participant when they were a minor is now of majority, then that's different. But and Melissa, I don't know if you agree with that.
Yeah, no, I think that's right. I mean, it raises the question, I guess, is really, once their status changes, is that initial consent still valid?
Right.
I think yes, but I guess I'd have to look into it more to be sure. But I agree with Stan's response that that's probably the right answer.
Yeah, facts always change the analysis, but given the kind of the high-level facts, I think it's probably a decent read.
Yep.
Okay, thank you, Ruth Hoffman, for that question. The next question from Solana is, does HIPAA specifically define unconditional research? Is there something comparable in the common rule? If so, are there differences?
HIPAA doesn't specifically define unconditioned research. They talk about it in the preamble, and there are lots of examples of what conditioned and unconditioned means. But with respect to research, they don't really. I mean, they provide a number of examples in terms of what would be conditioned or not conditioned. I mean, conditioned means that you have to, you have to sign the authorization in order to get the treatment or payment for that treatment. And if that's not a necessary condition, then it would be unconditioned. So, but I think they provide us a number of examples. With respect to the common rule, I think it's just much more flexible in terms of allowing different things to happen in the same document from a consent perspective. But I don't believe there's a definition there, or necessarily even really a concept there in the same way that there is a conditioned and unconditioned concept in HIPAA.
Okay, thank you. Any more thoughts on that one? Great. The next question is from the Oregon State Cancer Registry. Is there a consideration of a notice requirement for future research with option for patient opt-out?
Melissa, I mean, I think you answered the opt-out question earlier. I mean, I think they have to have an ability at some point.
Yeah, they have to. Well, yeah, they do, and I mean, you have to be able to. You have to have a clear opportunity actually to opt into the unconditioned component. So, I guess I've envisioned that as being a separate place that you would initial. If you'd be signing a form, it would describe the research. It would describe. I'm sorry, for future research, do you have to have an? Yeah, I guess I don't have more to say on it than that.
And the opt-out is an interesting one too. Traditionally we've had opt-out in research forever. Either as a withdrawal from the study where they just stop showing up, all the way to a proactive revocation, and those all create different operational activities you have to undertake when you get those requests. But almost always, it's the fact remains that you have to maintain the data, especially if this is part of a regulatory submission. You can't simply delete it, but you have to maintain and continue to use it in some manner, or at least escrow it and keep it in case regulators ask. And so, the opt-out is always extremely tricky in research, depending on what the actual use of the research data is, and having an opt-out even of a single individual where you remove their data, if their data is distinct enough from other data, could of course compromise the research. So it's always a tricky activity to honor an opt-out.
And I think in follow-up to that, I mean, the authorization, in terms of the question whether you have to have a notice for it, the authorization under HIPAA, you do have to include language that says something like, I, the patient signing it, understand that I have the option of revoking, that I may choose to revoke this in the future, and if so, here's the address I write to do so, and I understand that it means exactly what Stan was describing, that, that nothing that's already been used or disclosed in reliance on my previous consent changes, but on a going forward basis, there's no more disclosures of new information about me. But and then everything stands that applies about having to keep the information and being able to continue to use the information you had during the period which you had consent. But you do have to include language in that HIPAA authorization that notifies people of that option to revoke. So that may have been what the question was getting at.
There's a follow-up along this topic, and the question is, does the patient have the right to know about future uses when the future use occurs?
There's no provision in the rule now that says next time around you have to go back and notify everyone. And that's really no. So no, I think that was the kind of thing we were really trying to avoid, was what kind of consent can we get now that will give us adequate consent to do things going forward. But no, if there's a follow-on study and you have the right consent from the initial study, you do not have to let people know. You don't have to get them to sign something new, but you also don't have to let them know that there's a new study going on.
Thank you. Next question, does HIPAA permit making participation in a biobank conditional?
I don't think so. I don't know how it would be. I mean, there's no treatment associated with a biobank, so you can't require somebody to sign away their tissue and their information for a biobank in order to participate in the study, unless the care that they're getting out of it is related to that bank. I can't think of a situation where that would be the case. So typically that would not be something that you would be allowed to condition. You can condition only, and that exception is only for the clinical trial for research-related treatment. So it would have to fit within that exception.
Great, and this may be the last question, and it's for Stan. Can you reiterate the difference between opt-in and opt-out rates?
Well, yeah, I mean, it depends on where you are, what the type of study is, but clearly opt-out rates are a much lower. I mean, put it this way, when you have to take an action, it's a low percentage. And so if people are in a study, the opt-out rate is very low. And if you're not in a study or if you want to opt them into a biobank, typically the percentage is low. So in other words, we were advocating for the idea that we could do future research, we could do biobanking as part of a trial, and allow an opt-out, and that opt-out rate typically is less than 5%. Now that we are continuing to be forced to have an opt-in, even if it's a checkbox into a biobank, we anticipate that opt-in is going to remain low. I mean, historically, it really depends on the trial, but opt-in rates to do biobanking or sample banking are traditionally less than 30% of the participants in a trial, and so it's a significant issue. In Europe, they did a study and on organ donation rates. And they found that countries that have a de facto organ donation on death of individuals where the organs are donated, unless they opt out, had an organ donor participation rate of 90%. Countries that required you to opt in to donate organs had an organ donation rate of less than 10%. And so again, it's not unique to research; it's more human nature. And we actually don't think that it reflects what people would really do with research, unfortunately. But having a separate opt-in will diminish significantly the amount of participation. That's just the way it is.
Any other thoughts on the question? Great. Well,
I agree. It's a partial win, but not complete.
Yeah, I mean, it's a huge movement. I mean, let's be clear. I mean, it's a huge movement in the regs, and again, Melissa and Hogan should be given a lot of credit for the way that they help position things, and certainly Roy and the C Change team here has done incredible things that, at IU Clear we've been trying to do things for a long time, and really it wasn't until C Change got engaged that we were able to see movement. So it's really been tremendous activity, but there is more to be done.
Yeah, and this is Roy again. And I predict that if in a couple of years we have to revisit all of this, I suspect that the opt-in, opt-out question is going to be really at the forefront. And the second thing that I suspect will have to be addressed in a better fashion is the modernization of the de-identification rules, given how cheap it is for complete genome sequencing. And a lot of people feel that there's no such thing as de-identification anymore, essentially. So that's going to be another component, I'm sure, that's going to have to be revisited.
That's a great point. I agree.
Agreed.
On that note, I'd like to thank all of the speakers and participants again for this informative webinar, and remind the participants that if you have additional questions, please feel free to email me. My email address is on the screen. And also to remind you again, the webinar was recorded and will be available tomorrow through the C Change website. And if you follow us on Twitter or Facebook, you'll see information to link to the webinar there. Thank you again, and this concludes our webinar.